the ABA section of Civil Rights and Social Justice entitled The Power of Class Action Lawsuits, a Primer. This is the fourth panel in CRSJ's latest initiative, Civil Rights Lawyer Bootcamp, a two-day virtual summit that serves as a comprehensive resource for young lawyers, law students, public service attorneys, and advocates of all backgrounds. Thank you for joining us for the first day of bootcamp. We appreciate your participation and look forward to continuing the conversation next week during day 2 of our bootcamp. We appreciate you joining us during the last session of the day. During today's program, we encourage you to ask questions of our panelists through the Q&A, not the chat function. If you do not see the controls, please ensure your screen is not idle. Bring on a mouse and you'll see them at the bottom. We will be monitoring the Q&A and we'll do our best to address your questions. Time permitting, we will wait till the end to pose any questions to the panelists. We will share a recording of this program with everyone who has registered, so please share it widely with your networks. Today we have with us Jessica Stender. She's the Policy Director and Deputy Legal Director at Equal Rights Advocates. Barry Taylor, Adjunct Professor with University of Chicago Law School, and I am the Pro Bono Coordinating Attorney with Catholic Charities of Baltimore's Immigration Legal Services Program. Jessica will start by giving an overview of class action lawsuits. Jessica, if you want to let the panelists, let the attendees know how this works.
Okay. Hi, everyone. Thanks so much for the introduction, Heather. So we're going to start, as you heard, with just kind of a high-level primer on class actions and why they are such an important tool for vindicating the rights of various people. And so just as kind of a high-level overview, class action lawsuits have long been a really powerful tool for advancing a variety of different protections and civil rights, and also for achieving really systemic change while ensuring that people can vindicate their rights who may not have been able to otherwise. So in essence, they allow a group of individuals with similar claims to come together and file a lawsuit on a collective basis. So in many cases, the individual person, for example, a worker or a consumer, would not have actually been able to bring a case at all, even though they had experienced a violation of their rights and had, a viable claim. So, for example, in the case of a low-wage worker, or even a higher wage sometimes worker, who may have a wage claim, let's say a minimum wage claim or an overtime claim or another claim related to their wages, although there may have been a clear violation of the law, and those unpaid wages obviously take a very harmful toll on that person's life and their family's life, it generally just wouldn't be feasible economically for an attorney to actually take on that individual case, because the costs of filing a lawsuit and bringing a lawsuit would far exceed the economic recovery that could be obtained. And so by enabling a group of people who have similar claims, so in the previous example, if you had a group of workers who were not paid minimum wage or were denied their overtime wages, so they have similar claims, that then enables them to take action in a collective manner and bring a case on a class action basis that they otherwise may not have been able to bring at all. So it really does help to level the playing field against what are often large corporations or other types of institutions, government entities, et cetera, that might otherwise really avoid and evade their legal responsibility because an individual or even a group of individuals couldn't bring individual claims, but they can do so or could do so on a collective basis. And so there's been some really important landmark cases brought as class actions, challenging issues such as racial segregation, addressing workplace discrimination and gender pay disparities. Class actions have played an important role in enforcing environmental law protections and really just securing justice for groups of people who would not have been able to seek justice otherwise. In addition to providing kind of redress, often in the form of compensation, not always, and we're going to get into a lot of examples to see how these cases play out in reality. But in addition to providing compensation for people in some cases who otherwise would not have been able to achieve that, class actions also can be a really important tool to drive kind of institutional reforms by holding these corporations, governments, kind of large institutions accountable. And often, in addition to, or sometimes instead of monetary compensation that the company or institution has to pay, there's often really important forms of injunctive relief that provide for longer lasting changes. So, for example, and we'll talk more again in specifics later in the panel, but for example, in some of the employment class actions that I've been involved in, which I'll be discussing later, we not only seek compensation for the workers who were harmed and whose rights were violated, but we also seek what we often refer to as programmatic relief, requiring the employer to make changes within their workplace to ensure that these types of violations don't occur in the future. So that these cases, these class actions can have really important effect, not just for the workers involved or the consumers involved or whoever is involved in the case itself, but for future workers or consumers who might have been harmed by the entity involved. So kind of this isn't going to be a deep dive practicum on class actions, but we did want to give you an overview of kind of the main requirements of a class action so that when we're talking about these cases and the types of challenges that come up and how we as attorneys and others have navigated those challenges, we are grounded in the kind of requirements that exist. And so as I think some people know, the rules around class actions are derived from the federal rules of civil procedure, specifically Rule 23. And you probably have heard of people refer to Rule 23. That is the basis of these rules. Before I get into just a high level overview of the Rule 23 requirements, I want to just note that we are focusing today a lot of our discussion on these Rule 23 class actions, which we'll talk about in a moment, involve an opt-out procedure. But I did want to just note that there are other types of kind of collective cases that are separate from Rule 23 class actions, namely under the Fair Labor Standards Act, or FLISA. That act provides for a collective action, which is through an opt-in process. So we're not going to get very down the road on that, but I wanted to just note that that's another way for individuals, in this case workers, who have experienced violations of their rights under the Fair Labor Standards Act to bring collective cases separate from a Rule 23 class action. So under Rule 23, the kind of main requirements that we talk about are numerosity, commonality, typicality, and adequacy. And as you'll hear when we talk about, one, these requirements, but two, as they play out in cases, the reason for these rules are that the difference of a class action as opposed to an individual case is that in an individual case, a person, let's say a worker, or a consumer has experienced a violation of their rights. They decide, I want to bring a case, a lawsuit, again, bring a claim on my own behalf, or maybe two or three people decide to bring claims on behalf of themselves as individuals together. And they proceed to, bring the case, litigate the case. They might decide to settle, they might win, but it's all just on their own behalf. In the case of a class action, you have a person or sometimes a group of individuals that are referred to as class representatives or named plaintiffs who are bringing a case not just on their own behalf, but on behalf of other individuals who are similarly situated, who have experienced similar harms. And often, and we'll talk about this, that group of people on whose behalf the named plaintiffs are bringing the case, they might not even know that, one, their rights have been potentially violated. They might not even know that a case involving their rights is pending or is moving through the process. And so there are these specific requirements that apply to a class action to account for that different reality of this group context, class context. And so I'll just high level explain that these four requirements, what they are, and then we'll talk about how they play out in cases. So the first, numerosity, requires that the class of people has to be so numerous that joinder, which is of course a legal term, of all of those people is impracticable. Now, there's no hard line rule of how many people have to be in a class for it to satisfy the requirement of numerosity, although often 40 is a number that is looked at, but there's no the rules do not provide for a specific minimum number. The second requirement of commonality is that there has to be questions of law or fact that are common to the class. So obviously, to make it kind of worth the court's while to treat this in a collective manner, as opposed to a number of individual cases, you want to make sure that the claims and facts involved are sufficiently similar that it makes sense and it's more economical for a court to treat them as a group or class case. The third requirement is typicality, and that means that the claims of those named plaintiffs or those representative plaintiffs have to be typical of the claims of the broader class, which again makes sense because they're bringing a case on their own behalf, but also on behalf of others. So we want to make sure that their claims are sufficiently similar and that those representative parties have typical claims that are similar to those of the class. And then finally, adequacy. That has to do with ensuring that the representative parties, so the named plaintiffs, will fairly and adequately protect the interests of the class. And again, this goes back to that reality that there are class members who may not even know that they have claims. They may not even know that there is a class case moving along. And so we're going to talk some about how this plays out, but in another kind of difference with a class case as opposed to an individual case is that if you are involved in an individual case on your own behalf, if the defendant proposes a settlement to you, you have the choice to accept that or decline that, and that's your choice. However, in the case of a class action, the named plaintiffs or the representative parties have to make a decision for not only their own best interest and what they want as individuals, they have to make it on behalf of the best interests of the class. And so that question comes up in various ways, but with regard to settlement, when a settlement is being discussed or proposed in a class action, there needs to be an effort to ensure that the settlement is fair for all of the named plaintiffs, but also the unnamed class members who are likely within the class. And so the way that plays out is that when a settlement has been proposed, the parties, the named plaintiffs, have to file a notice with the court of the proposed settlement and have to go through not one, but two hearings to determine whether that settlement can actually be agreed upon, whether it is fair enough for that big class of people for the court to approve it. And the court has to approve it. And so you have a first kind of process, first phase of that process is the first hearing, often called the fairness hearing, where their court will evaluate the proposed settlement, look at the potential class members, the numbers, the amount of money that is going to approximately go to each person, the types of relief, and look at and ensure whether it's fair. The court will also want the parties, the named plaintiffs, to show their proposed plan to get notice of the proposed settlement to all of those class members so that they are aware of the proposed settlement, so that they have the opportunity to opt out if they want to opt out, and that they can show that they've gotten fair notice, given that their rights are at play. Once a court has granted that preliminary approval of a class settlement, then the parties engage in the notice process. They send notice out to all the class members, and we'll talk some about challenges that come up and ways that we can address those challenges in a moment. And they give class members the opportunity to sign claim forms, often if there's money involved, so that they can sign a claim form and get money. You may have received those in the mail. You should fill them out and make sure that you get whatever relief you are entitled to as a class member in these cases. And then after those claim forms are sent in, and the court will do another hearing to determine whether the process has been carried out sufficiently, and ultimately determine whether they will grant final approval on the settlement. And if they do that, Then in the case of monetary compensation, it will go out to class members, to named plaintiffs, and the matter will be settled. And if there is injunctive relief or programmatic relief that the defendant has agreed to, and we'll talk a bit about how this might be monitored, then that defendant will have the obligation to comply with whatever forms of programmatic relief they have agreed upon. So that is a kind of high-level discussion of some of the requirements of class actions, some of the particularities with regard to settlement. I'm going to turn it now to Barry to talk about some actual examples of how these play out, and then I'll come back with some examples from my practice, and we will save time at the end for some questions.
Great. Thanks, Jessica. And hi, everybody. Pleasure to be with you today. Again, Barry Taylor. And while I am at University of Chicago teaching disability rights law now, for 27 years, I was the Vice President for Civil Rights and Systemic Litigation at Equip for Equality, which is the protection and advocacy agency for people with disabilities in Illinois. And that's where I did the bulk of my class action work. Over the 27 years, I worked on about 8 class actions. And I'm going to give you some examples from some of those. And we worked on what are called 23B2 class actions, meaning only seeking injunctive relief. And Jessica has experience involving those that have monetary damages. So you have experience from both sides here. So I'm going to divide up my 20 minutes in talking about 3 things. One is some strategies regarding pre-litigation. Second, about litigation of class actions. And then third, settlement and implementation of class action agreements. So with respect to pre-litigation, I know we have some folks here who may be interested in volunteering or getting involved and working on class action. So I'm going to talk about some opportunities there that occurred in some of the pre-litigation activities of the class actions I've worked on. You know, it's really important to have everything together before you file, and you can do a lot before you file in order to make sure your class action is successful. The first class action we filed was against the Chicago Transit Authority for its failure to make its trains and buses accessible to folks with disabilities. And before that, we filed that litigation, we used law students and volunteers and our own staff to do a lot of work. We did testing of the systems where we had somebody from our team riding with people with disabilities all around Chicago on the buses and the trains, and then documenting that information that could then be used in our complaint. It was also an opportunity to assess whether that person might be a good named plaintiff. We also obtained a lot of information from FOIA. The feds require transit authorities to keep a lot of documents, and we were able to get a lot of information, sort of pre-discovery documents. And then we also did a lot of outreach to individuals to let them know what we were working on, to get individual documented complaints. And we had volunteers in our team working really hard doing that outreach. We got over 300 complaints that we were then able to use in our complaint, as well as, again, identifying potential named plaintiffs. And then, of course, a lot of legal research was done before, and obviously law students and volunteers can be very helpful with that. We also did a class action on behalf of people who were living in institutions in Illinois who wanted to live in the community. And for that class action, it was really important for us to do visits to all these different institutions to really document a lot of the issues that we were concerned about, as well as to, again, talk to people, recruit named plaintiffs, and that sort of thing. And I mentioned recruiting named plaintiffs because that's a very important component, because they are, as Jessica said, are representing the broader class. And you need to be really careful on who you select for that, because they have an important role. And frankly, it can be very challenging to recruit named plaintiffs, especially in the institution case, because basically they're going to be testifying negatively about where they live and the people who serve them. And so people can be concerned about retaliation, and we can maybe talk about that a little bit later. We also did a couple of prison class actions, and again, did a lot of visits to prisons and recruited plaintiffs, documented conditions. We also, when we were in the prisons, we helped people do what's called exhaust administrative remedies. So for a lot of litigation, including some class actions, especially in the prison context, you can't go forward with litigation unless you exhaust those administrative remedies. And that can be difficult for people to do by themselves. And so again, that's a great opportunity for students and volunteers to help people with that process, so that they are then ready to go as plaintiffs and class members in the broader class litigation. That's an overview of some of the pre-litigation activities. I'm going to move now to sort of the litigation aspect of things and spend the bulk of my time on that. So in all the class actions that I worked on, I mentioned we worked on 8 different ones. We never brought those class actions by ourselves for a couple of reasons. One is we always wanted to have a pro bono law firm with us, because these class actions are very complex. They're very document intensive, at least the ones we worked on. And the law firms had that infrastructure and litigation software that we just didn't have. And so they were incredibly helpful for that. Obviously, they have a lot of litigation experience, even if they're not experts on the underlying substantive area. The litigation experience and class action experience and federal court experience is very invaluable. But in addition to the pro bono attorneys, which were so important, we also, in our cases, brought it along with other public interest organizations. And we felt that was really a great strategy because it allowed us to engage public interest agencies that perhaps had expertise that was different than ours. So in our prison class action on behalf of people with mental illness and another one on behalf of prisoners who are deaf, we had the disability experience working with those populations all the time in all kinds of venues. But we also partnered with an agency that really focused on assisting people in prisons, Uptown People's Law Center. And so we brought together our litigation experience with their prison litigation experience and then the pro bono attorney experience to make a really, really effective team. I'd like to, if you look in the materials, there's an article that I wrote about the collaboration we did on our institutional class action. And the reason I highlight it is I think it's kind of unique in that class action brought together 3 different public interest agencies to work on 3 different class actions concurrently. And it really turned out fantastic. And so I think it might be a model that people look to as they're thinking about how to bring those class actions. So this is a case involving people who want to live in the community with disabilities, but they're in institutions. And we had a great Supreme Court case that said that folks are entitled to live in the community, but Illinois, unfortunately, was one of the worst in the country, ranked 49th out of 50 states on serving people in the community. Before we filed our class action, we reached out to the governor and said, we want to work collaboratively with you, and our letter was ignored. So that made us know that litigation was really the only other option. And so there were 3 organizations, Equip for Equality, the ACLU of Illinois, and Access Living, that were all interested in this issue. So we said, let's work together, pool our resources, and see if we can figure out a way to address these issues. As we did our research, though, we recognized we couldn't just bring one class action because of the way Illinois is structured. With different types of disabilities, they were covered by different types of bureaucracies. And so we decided we really needed to bring 3 different class actions, one on behalf of people with developmental disabilities, one on behalf of people with mental illness, and one on behalf of people with physical disabilities. And so ultimately what we decided from a sort of division of work standpoint is that each of the individual public interest agencies would be lead counsel on one of the 3 class actions. And we ended up choosing the ones that we had the most substantive expertise, so it worked out well that way. And as far as lead counsel, it's in a really important role. One of the things that we said the lead counsel needed to do was to recruit the pro bono firm. And so we used our different networks to do that because, again, these cases really need that level of support. And we always, in these cases, worked with pro bono attorneys who were willing to donate their fees in the event we're the prevailing party or there's a settlement. Under the Americans with Disabilities Act, prevailing parties can get their fees returned to them. And so that can be tremendous for public interest agencies to not only recover their own fees, but get those from the pro bono attorneys. And that allows us to do more cases in the future. And fortunately, we were able to recruit firms that were very kind in not only donating their time, but also donating those fees as well. The lead counsel also organizes the team, delegates assignments, takes the lead in court, also takes the lead on PR, which is a really important component in a lot of class actions as far as how you're presenting yourself to the public, identifying, working, and recruiting with experts, overseeing all the litigation costs and being in charge of making sure everybody's sort of paying their share, and just making sure that the litigation is moving forward and all the different aspects that can happen there. We also sometimes would be negotiating a settlement at the same time that we'd be preparing for trial, and sort of figuring out who's doing what and sort of dividing that labor would be very important as well. And then, of course, you want to make sure that you have all your ducks in a row, right? You need to have your co-counsel agreements that lays out what it is you're going to be doing and how the fees are going to be divided and all that sort of thing. You also need to make sure that you have, just like in any case, you need to have retainer agreements with your named plaintiffs. Obviously, you don't get retainers for all the members of the class because in our cases, we're talking about thousands of people. But your named plaintiffs, you do need to have class retainers with, because when you file for class action, we haven't really talked about this yet. You file saying it's you want it to be a class action, but you can't just deem something a class action. You have to file a motion for class certification, and the judge goes through a lot of the factors that Jessica mentioned to determine whether it should be move forward as a class action or not. So before it's a class action, you have your individual clients and named plaintiffs, and of course you need to have the retainer agreement and make clear their understanding sort of what their role is, not only as litigants but also as class representatives. And it's also really important to work collaboratively with the community, because when you're working with the community, it's just critical that they are aware of what you're doing, so they don't feel like you're sort of acting without the broader community's interests. So when we did a lot of our disability litigation, we would meet with a lot of disability groups and say, look, we recognize this is a problem, and this is what we're going to do. And oftentimes they might help us identify other class members, or they might be able to identify people who've had issues or document problems or those kinds of things. They're also really helpful when you're doing your press and your PR, because it doesn't look like you're doing something from an ivory tower by yourself, pontificating, but instead that you are responding to the needs and the concerns of the community, and that your class action is one strategy to try to resolve some of these systemic problems that are facing the community involved. All right. The next thing I just wanted to mention is sort of what happens at the end. As Jessica said, there's sort of this preliminary approval, and then there's a fairness hearing. And I wanted to mention that although typically you would start a class action at the beginning, you file it as a class action, there are times when you file as a case and it's converted to a class action via the settlement process. And so the Chicago Transit Authority case that I mentioned before, that's a great example. We filed that on behalf of an organization, on organizational plaintiffs and 9 individual plaintiffs. And strategically, that just made sense for us to do it that way. And we can talk about the strategies of a group action versus a class action if people like in the question and answer period. But that made the most sense for us to do that for this particular case to get it moving. But when we settled, our opponent said, we will settle, but we'll only settle if it is converted to a class action. And so people may not be aware, but the settlement process, you can have what's called a settlement class, even if you didn't have an underlying litigation class. And then once you go through that process, then some of the things that Jessica talked about as far as the notice and opting in and objections all kind of come into play at that point. And you might ask, why did the CTA want to have it settled as a class? Well, as they said, they wanted peace. They didn't want us to settle this case and then have other people with disabilities say, well, what about, me, and what about this and that? And so it gave them basically 5 years of ensuring that unless somebody opted out, they were covered by this case if they were a person with a disability in Chicago riding the trains or buses. As far as the notice that Jessica mentioned, at least in our cases, typically that's paid for by the defendant. Now, even though they pay for sort of the broader notices in the papers and all the other things that you do, you certainly as plaintiff's counsel can do a lot of work on getting the word out. And we would have meetings with class members and at organizations just to make sure people were understanding what the class settlement was all about, and ensuring that they were sort of on board and potentially could be supporting our fairness hearing coming up. And as far as fairness hearings, I hate to do this because it's sort of exposing one of my biggest challenges that I had that didn't go well. Ultimately, it turned out okay. But we had one class in our institution class where we had a lot of objections to our proposed settlement. We think we broke a record for the most objections in the history of the Northern District of Illinois. Over 2,000 objections were filed. And this was a case, without getting into the weeds, involving parents of people in institutions who didn't want their loved one to move. And even though we didn't think that was what would happen, and people had the choice to move or not move, that's how it was characterized by the objectors. And these objectors were incredibly aggressive and frankly persuasive to the judge, because we had received preliminary approval, but at the fairness hearing, once he heard from all these objectors, he ended up not only throwing out our proposed agreement, but also decertifying our class. So we went from representing 12,000 people down to 6 people. And that was pretty devastating. And it really taught us about how important we needed to be as far as how we crafted our message and how we litigated the fairness hearing itself, because it really is potentially a litigation opportunity by bringing in witnesses and experts and that sort of thing. And we also learned that it was decertified because of typicality. The judge said that our named plaintiffs were quote unquote high functioning and they could live in the community, but the parents were arguing that their quote unquote lower functioning family members couldn't live in the community. And so since none of our named plaintiffs were those who were quote unquote lower functioning, he found that our named plaintiffs were not typical of the broader class. So if I could do it all over again, I would probably have set up our named plaintiffs in a different way to address that concern. Even though I didn't agree with that concern and didn't think that was correct, it certainly was helpful. And what that did was that informed the fairness hearings for our next 2 class actions that we had that were related to the first one. And we sailed through both of those fairness hearings without any changes, even though we still had quite a few objections. And so again, I think learning from those experiences can really make a difference. I also just wanted to mention that there's a difference between a consent decree and a settlement. So a consent decree inherently means that the judge will retain jurisdiction, and we would always be advocating for a consent decree because these are complicated cases, and it's very difficult for a defendant to, perfectly implement a class settlement, even with the best of intentions. And so, just to give you a sense, we settled those 3 institutional class actions in 2011. All 3 of them are going on. So the actual implementation has taken longer than the actual litigation of those cases, which were filed in about 2005 and 2006. So you have to be prepared for the implementation side of things and put the resources there, and having a consent decree ensures that that happens. Finally, I just want to mention a couple of final points. We think it's really important in these systemic injunctive cases to get an independent monitor as part of your settlement, to be the eyes and ears of the judge. Otherwise, it falls on you, and that's a huge burden to take on. Oftentimes, you don't necessarily have the substantive expertise that an independent monitor would have. So that's always a big negotiating point with us for that. Sorry, my dog's hearing somebody at the door. Also, just wanted to mention as well that, pro bono attorneys love the litigation side of things, but the implementation side, which is often policies and things like that, they're not as interested in. So you need to know that that's something you may have to take the lead on. The pro bono attorneys may be there just for enforcement purposes. And then finally, I just wanted to say that an important component, at least in our cases, are attorney's fees, as I mentioned, and that's built into settling the case of the attorney's fees that were incurred prior to the settlement. But what about the implementation side of things? How are fees handled there? Are you able to recover fees for your monitoring efforts if there isn't an independent monitor, or even if there is? Or are you able to recover fees for enforcement of the decree if they don't comply with the decree? Now, certainly you can make arguments as to why you're entitled to that, but we think it's very important to put that in the settlement or consent decree ahead of time. Obviously, it's a big negotiating point, and some defendants are or aren't going to necessarily agree to that, but sort of keeping silent about that in the agreement really is a trap for the unwary. And you want to make sure that if that's an important negotiating point and an important point for you to be able to have the resources to do what you need to do to implement this consent decree, that's something you talk about and negotiate right up front to ensure that there's no questions and you're not leaving up to the judge to decide whether you're entitled to those fees or not. So Jessica, I'm going to pass it back to you to give additional examples, and then I guess we'll open it up for questions.
Thanks, Barry. I'm learning a lot from being on the panel with you and hearing about these cases. I hope for everyone who's watching, our goal was to show how kind of the high level rules that exist in class actions really play out on the ground. And so that was very helpful, Barry. Thank you. So I want to kind of echo a lot of what Barry said. I'm going to give a few examples of cases that I've worked on, class actions that I've worked on, and some of the kind of challenges and how we met them, and try to address a couple of the questions I saw in my presentation. And then, as Barry said, we'll have time for some questions at the end. So I wanted to note that, as you might imagine, my experience is all in employment law. I'm always been workers side, workers' rights employment attorney. And because of the requirements that we've talked about in class actions, the kind of wage claim class actions like minimum wage or overtime are sometimes a bit more straightforward. Nothing's ever really straightforward in law, but a little more straightforward because you'll often have, records, pay records, et cetera. And I did want to note, though, that there are also successful class actions in the realm of discrimination. And you also heard, of course, about accommodations and disability rights from Barry. And so one of the cases that I was going to highlight for you all that we brought at Equal Rights Advocates was on behalf of a class of pregnant or people who had been pregnant, who worked in grocery stores, this was people in California. And in California, we not only have protections against pregnancy-related discrimination, but we also have a requirement that pregnant people who need a reasonable accommodation at work have to be given that accommodation. Keyword is reasonable. So it has to be an accommodation that can be given and they can still do the core duties of their job. And often pregnant people can do the core duties of their job with a reasonable accommodation, without an undue burden or cost to the employer. And just side note, because it's an important win to mention, for a long time, just those types of protections and requirements related to reasonable accommodations of pregnancy were only in several states, including California. But as a result of the Pregnant Workers Fairness Act, which was passed 2 years ago at the federal level, those requirements related to reasonable accommodations now apply across the country. So just a side note on that. But back to the case. In this case, the pregnant people who had been working in supermarkets would come to their employer and say, "Hey, I'm pregnant. My doctor said I have to work with this accommodation." Examples of accommodations are things like a lifting requirements, so not lifting over a certain amount of weight, having a stool to sit on, having more frequent water or food breaks. Those are some of the kind of typical accommodations that we see a lot for pregnant people. And in this case, the workers were going to their employer and saying, "Hey, I need this accommodation." And the employer was outright saying, "We can't accommodate you. You need to go out on leave." And in addition to the requirement that employers provide reasonable accommodations in California and now across the country, there's also a requirement that employers engage in what is called the interactive process. So if an employee comes to an employer and says, "Hey, my doctor says I need this accommodation," the employer has to at least discuss the needed accommodation and see whether it can be made, see whether that worker can still do their job without an undue burden on the employer. And they may ultimately determine as a result of that interactive process, no, we can't provide that accommodation. It would create an undue burden on us as an employer, or the worker could not do the central duties of their job, but they at least have to engage in that process. So in this case, they weren't engaging there. And so we brought after attempts, which, as I'm sure everyone knows, you often don't just file a class action. You attempt to resolve the matter without having to file a lawsuit. After various attempts, we ultimately filed the lawsuit. And just to kind of get at some of those requirements that we mentioned earlier, we were able to show that our named plaintiffs had experienced this issue of being denied an accommodation outright and being pushed out on leave. And a number of other, and pretty much all other pregnant workers during that time had experienced the same issue. Also, and this kind of goes to broader methods of showing commonality in class actions, we were able to look at employment handbooks and personnel handbooks that didn't have the kind of appropriate protections and requirements in them. So those were some of the other ways that you can show in these types of cases common claims and facts, or common facts in these cases, is whether an employer, had appropriate procedures in place related to whatever the claim is in the case. And in this case, we were able to reach a settlement for those pregnant people. And not only did we get compensation for the people who had been denied accommodations and put out on leave, which of course affected their earnings, but we also were able to get pretty good programmatic relief to ensure that the employer made changes so that these issues wouldn't occur going forward. I want to also just echo the comments of Barry in terms of having an external monitor, if at all possible. We've also been involved in a number of pay equity class actions. And in those types of class actions, when and if the case settles, you might have some compensation for the named plaintiffs and the class members, and often some programmatic relief to require, for example, that the employer conduct pay equity audits going forward a certain number of years to ensure that they are vigilant against kind of gender or race-based pay disparities, and they don't creep back in. And we will often require a monitor, an external monitor, for precisely the reasons Barry mentioned. So I won't go into that, but just wanted to emphasize the importance of that. Quickly, before we turn to questions, I did want to talk about some of the kind of interesting challenges that I've experienced in class actions and how we've dealt with them. And it does bring up some ways in which, if you wanted to volunteer, you might be able to support in these class actions. So in my prior position, I was the legal director of an organization called the Center for Migrant Rights, Centro de los Derechos de Migrante, and worked with migrant workers, mostly from Mexico, who came to work in the US. A lot of those workers came on temporary visas, working in the US in agriculture or in other fields, industries where employers were not able to find US workers, and often experience, as not surprisingly, violations of their workplace rights. And in a case like that, it can be difficult to find even though there was clear kind of class claims, big groups of workers who were experiencing violations of their rights, it can sometimes be hard to find lawyers to take those cases because you have a workforce that's kind of inherently transient, migrant, going back and forth between two countries, especially with these visas. They are, temporarily in the US, going back home, and going back and forth. It can be very hard to get notice to them of a class action potential settlement. It can be hard to get money to them. And so we, at my former position, would support attorneys who were bringing those cases from the US by kind of dealing with those challenges. And so, for example, in the case of these Mexican migrant workers, we would, because we were based in Mexico, go out to the communities where we knew a lot of the class members had come from to provide them with the explanation, the notice of the class settlement. And as you might imagine, for a lot of these workers who weren't very familiar with United States law, and often didn't even speak English, it took some work to explain to them, what is a class action? What is this notice that I'm receiving? What does it mean? What are my rights that are involved? And so we found that it was really helpful to go out in those communities to explain to them what the case was about, why they were being notified, that they did have a chance to opt out if they wanted to. And then similarly, when it came to signing claim forms, explaining to them what they were signing and why, ensuring that they understood it wasn't a scam. As you can imagine, workers, especially lower wage workers, are not used to being told you're going to get some money from a case being brought. And so making sure they understood the process. And then even the piece of getting money to workers in Mexico, it wasn't in those times, and still isn't as easy as it is in the US, to receive a check and go deposit it. It just doesn't work that way, or it didn't at the time in Mexico. And so we came up with some innovative ways to get money to workers once they had filed a claim form, and once the case, final approval was granted and money was being distributed. We wanted to make sure that we got them that money. And that that final piece that I want to touch on before we turn to questions, is a big one. Once you have the payout of the money, it can sometimes be hard to find workers in the US as well. And all of us who bring these cases, class action attorneys who are bringing cases, whether it be on behalf of workers or consumers or anyone else, are very focused on making sure that the individuals who have been harmed receive their compensation. And that can be difficult. People move. You often use the last known address that the employer had, in the case of an employee, right? That the employer had for the worker, and people might have moved on. Certain communities are, more likely to have moved on from their last place of residence. And so In the supermarket example that I mentioned to you, the pregnancy accommodations case, in that case, a lot of the people who had been pregnant, were a bit younger. They'd been working at a supermarket, and by the time this case was brought, they were no longer working there. They were no longer at the place where they had lived. And so we actually, when we did our first round of distribution of funds to those workers, we actually had some difficulty finding them, of claim forms, excuse me. We had some difficulty finding them, and we really had to do some kind of innovative work to not just send the notice out to the addresses, but we did a lot of social media sleuthing, looking for them online and contacting them that way via social media. Again, having to explain kind of what is this case about? What does a class action mean? Why are you being offered money? In some cases, in these cases, sometimes by the time it gets to class settlement and money, claim form distribution and money distribution, sadly, class members may have passed away. That came up in that case. It's come up in a number of cases. So trying to find their next of kin and explain to them that the person was entitled to money, and that whoever in kind of the estate process was entitled to that can still claim that money. And so we thought of some innovative ways to get to people. And so I wanted to just kind of mention those as examples of where these types of cases can be complicated, but there are ways that the creative ways you can find to get people notice of their rights, and hopefully get them some compensation. So those are, I think, the high level points we wanted to touch on. Barry, anything else you wanted to add before we move on to questions?
No, I think that was great. Thanks, Jessica. I did see one question. I just thought I'd go ahead and grab, Heather, if that's okay. And that was a question about concerns about the other side talking to your class representatives. And that's why the retainer is so important, because you have a retainer with them. They are represented by you. So all the ethical responsibilities and duties that go to not contacting representative parties would apply there. And it's even more, I may have referenced this before, but just to be really clear, your retainer for them is not just about your individual assistants. It's also about what their responsibilities are as a class representative, and making clear that they are looking to be helpful to make decisions for the broader class. And so you just want to be really clear ahead of time with people to know what their responsibilities are. And even in injunctive cases, like our transportation case I mentioned, we actually negotiated some payment for our named plaintiffs. And there's justification for that because of what they have to do as named plaintiffs, right? I mean, they're putting their lives on the line, they're testifying, they're giving depositions, they're sharing a lot of information about their disability in our cases, that kind of thing. And so even in injunctive cases, named plaintiffs can be compensated depending on how it's all negotiated. But I just want to be really clear that they are represented clients, and so all the rules, ethical rules that apply wouldn't happen. Now, obviously, as Jessica mentioned, you can have named plaintiffs who can die. You can have named plaintiffs who can get relief sometimes, like maybe an institutional plaintiff is given a community placement, and they can try to moot out your named plaintiff sometimes. And that's why getting it certified is really important, or perhaps using an organizational plaintiff before certification. So there are a lot of different strategies. You want to have usually more than a couple of named plaintiffs, at least in our cases, again, for some of those mooting issues and conditions of people maybe dying in, that sort of thing. So there are a lot of strategies that go towards that named plaintiff component, but again, they are represented clients and all those rules apply.
Great, thank you so much. I learned a lot from your panel too, and I was taking notes. And the first question is, how do you deal with harassment that might come from bringing class action suits? The person references housing class action that leads to physical retaliation to individuals in their unit, and curses of people that might not be solely by bringing claims to the court, but that the ethical standards of judges are not being evaluated, especially true when translators are used.
Well, I can jump in first, and Jessica probably has some thoughts too. I mean, for us, one good thing for us is under the Americans with Disabilities Act, there's a separate cause of action for retaliation. And so we could certainly add that, saying that people are retaliating for exercising their rights, which, filing a complaint under the ADA is exercising your right. So it's sort of a classic retaliation, and it's a separate cause of action from the underlying discrimination. The other thing is, and we did this, is bring those kind of things to the attention of the judge. We had a situation where the other side was harassing our plaintiffs and actually having improper communications with our plaintiffs. And we let the judge know, and the judge issued a scathing opinion. And I think it actually helped us in the fairness hearing because the other side had acted improperly. And so I think, letting the judge know is another strategy that you can use.
And I was going to mention, I'm glad that this question was raised because in any, again, focusing on the kind of employment context where I've done most of my class action work, in any potential litigation, there is a very real fear of retaliation for workers, really all workers, but especially low-wage workers who may not have a safety net if they are in fact retaliated against. And so while there are clear protections against retaliation, and we always make that clear with workers when they are considering bringing any type of litigation, including whether they are considering being a named plaintiffs, we always talk really clearly about the real potential for retaliation. But we make it clear that there are separate legal claims if you are retaliated against. I will note that the kind of class action tool is just really important in so many ways, and this issue of retaliation is one of the ways that class actions really are so helpful, because yes, you have a named plaintiff or a few named plaintiffs, representatives, class representatives who are the kind of face of the case and have their names on the lawsuit. But because they are able to bring this lawsuit on behalf of this big class of, unnamed workers, it is a way that if you can find a few people who are brave enough to take that step forward and feel comfortable doing that, they can then kind of help those class members obtain relief for violations of their rights when they might not have been comfortable bringing a lawsuit on their own. So it's kind of a way to get that type of relief, especially, let's say, in the context of, a big group of immigrant workers. If you can find one or a few who are willing to step forward, that means the rest can kind of benefit from that case without having to put their names or themselves out there.
Yeah. I saw just a couple of folks having a hard time finding the article that I referenced, and just wanted to help guide folks in case you didn't see the response. If you go down to the toolbar to the left of the Q&A is a button for resources. And if you click on that, you should be able to link to the article that I referenced.
And Heather, I'm happy to just kind of take another one that I saw, if that's helpful.
Sure.
There was a question about kind of strategy, and Barry, you touched a lot on this, which I thought was great, just kind of how to decide what cases to bring. And that's, of course, there's so many questions of, venue and jurisdiction, et cetera. But when we have been determining, of course, it depends on what comes to you, but when we have been determining whether and how to bring a class action, we are very careful to consider kind of how, in my case, in my organization, we're a small nonprofit. We, generally co-counsel with others, and I'm sure, Barry, you've experienced this. You want to make sure to bring a case where you think you have a likelihood, strong case and likelihood of success. And you really do need to look at those 4 requirements, within a class action, to look at where there may be holes, because by definition, humans are different. And so, of course, the defense in a class action is always trying to point out why your named plaintiff's claims are not sufficiently similar to those of the class, or the facts that occurred, with regard to your named plaintiff are not sufficiently similar to those of the class. So we look really carefully at kind of how close those potential claims are, and whether there's enough holes that could be poked in that case to where we wouldn't actually be able to meet the class certification requirements. And again, making sure you have a good named plaintiff. As Barry said, you want to make sure that they are in fact the right. You might have a really righteous plaintiff who's really, would be great in many ways, but once you look at their claims, they have too many individual issues that would not be apt for class certification. And there again, you're just really looking at the fact that this is different from an individual case. This is in the benefit of the class, and would this person be the best representative of that broader class?
Yeah, and I just to add on, those are all great points. I think also a lot of times when we're kind of looking at issues, we will do a few individual cases just to kind of get a sense of, sometimes you can get systemic relief through individual cases. So we brought some individual transportation cases, and the problems remained. So that's one way is kind of just to, and then you can actually show we tried and things didn't happen. So class relief is really important, or organizational plaintiff is really important to get systemic change. So that's really important. We also had an annual process, and this may not work for everybody, but we had an annual priority setting process where we gave people the opportunity to give us input on what they wanted us to do. And a lot of our ideas for our systemic litigation came from those meetings. And, again, that just shows that you're being responsive to the community and doing things that they're concerned about, and they also can identify issues that you may not be aware of. So I think doing outreach ahead of time as part of your process on deciding what to do and when to file and all that sort of thing is really helpful. And then the only other thing I would just add as far as that class representative thing that's also really important is class actions take a long time typically compared to individual cases. And so a lot of individuals will be like, I think I'd rather just do an individual case and get it resolved because I need my kid to get this, or, like a special education case. And so it's not the right fit for a lot of people, but there are people who are like, I'm here for the cause. And those are the people you really want as your class representatives, because they understand that what they're doing is not only going to help themselves, but many, many other people. And they feel like they're being, part of a social justice movement. And that's really key. I also saw a lot of people just asking, what can law students do? And I think Jessica and I tried, I think, through our presentation. Hopefully you got some sense of that, different kinds of research and outreach and different kind of activities that can happen. But as far as how you find those kind of things, I mean, there are a lot of organizations out there that do class actions. And I think if, if you're interested in doing that kind of work, maybe working with your law school placement folks, because they might be able to help identify things, or even doing, if you could do internet research on a topic like employment and class action, you're probably going to pull up Jessica's group, or disability class action, our group might come up. So think about the substantive area that you're interested in, and then try to navigate to people who work in that area, or even just do some internet research, and hopefully you can find some places. And most folks are interested in having volunteers, especially if you can delegate a decent amount of time for the commitment, because they're very resource intensive, and it's always helpful to have more cooks in the kitchen.
Agree. I think those are all really great suggestions. There was a question about kind of the amount of money that might be provided for in a settlement. And, I think the nature of some class actions is that the amount of money that, I'm talking monetary right now, that an individual class member lost, for example. So let's say a credit card unlawfully charged an extra $2 to all of its, a credit card institution unlawfully overcharged all of its credit card holders, millions of people across the US, a couple dollars extra every, year, say. So that individual person would definitely not be able to find an attorney to bring a case on their behalf, because while it is completely unfair and unjust that the banking institution unlawfully charged them this fee, the $2 a year extra or whatever it was it would not be economically feasible to bring a lawsuit on that person's behalf. And so in that case, you would potentially have a class action settlement that may be pretty large in the total monetary amount, maybe in the millions of dollars, but because there are so many class members, the individual relief that each person receives is not very large. And so part of what we talked about with the requirements that the parties submit a proposed settlement to the judge, to the court, and that the judge evaluate that proposed settlement for fairness is where we make sure that the judge really needs to take into account how many class members are there, what is the kind of approximate harm they each suffered, What is the total amount of money that is potentially, you know, going to be part of this settlement? What is the other relief, you know, whether there's kind of other injunctive relief that adds additional fairness to this? What are the attorneys getting? And in the correct course of action, the judge will make that assessment and really ensure that looking at the settlement as a whole and the case as a whole, that monetary amount is fair. And so, you know, that's kind of a decision of the judge. You know, I saw the question there. You might have a judge that makes a bad call in someone's view, but that really is kind of the functioning of those preliminary approval and the final approval hearings is really to ensure that there's fairness and how much is being agreed upon. But that's not to say that there have been attorneys who have settled cases that may not, you know, one may not have believed were fair to all the class members, but there are for sure many class actions that have resulted in settlements for workers and consumers and others that would not have received any compensation but for the class action process.
Thank you. We have several more questions, but I got a 1-minute warning a few seconds ago. So I want to thank you all for joining us in this free session this afternoon. Thank you for staying with us all day and staying with this last session. It was very informative for myself included. We'd like to express our gratitude to this esteemed group of panelists. You are all doing such great and important work, and we thank you for taking time out of your schedule to share your experiences. The section of Civil Rights and Social Justice provides free webinars and resources for legal professionals and advocates nationwide. We hope this helps you in your work. And again, if you can, please consider joining and becoming an active member in the American Bar Association. You may do so at americanbar.org/CRSJ. Thanks for staying with us and join us next Friday for the second day of the boot camp.